off with, first of all, welcome to the show. This is going to be a show where we discuss the legal profession in South Africa, we discuss law and order, and more specifically, we find a legal expert, somebody who really knows what they're talking about, and we dispense advice that the everyday South African might not be able to get hold of. Sometimes legal advice can be very expensive, or it can be hard to contact a lawyer, or maybe you just have trust issues. But I've found somebody that you can definitely trust, that definitely knows what they're talking about, and we're going to get into today's show. And the first topic, very popular topic on the South African legal landscape, is the matter of deceased estates. So let's get into it with Tutu, our esteemed colleague from Mgiba Law, and let's talk about that. Welcome to the show.
Thank you for having me. Yes, the name is Tutu Mgiba, commonly known as Tutu. Yes, I am a director and founder of Mgiba Law, and thanks for having me here today.
It's a pleasure to have you. We know that you've got a lot of valuable advice to share with South Africans. It's quite a common thing in South Africa because I might say that sometimes, even though we have one of the best legal professions in the world, I mean, our standards of legal profession in South Africa, making no mistake about it, we're amongst the best in the world. I know people often complain, but just as an example, you've got to remember that it was lawyers and the legal profession that literally stopped the South Africa collapsing in its entirety during the apartheid era and in the post-apartheid era as well. I mean, it was lawyers that freed people like Nelson Mandela. So I don't think it's fair to give the legal profession a bad rap. We have one of the best in the world. And having said that, it can also be a little bit clumsy sometimes, maybe at the police station level or at the court level. But we're going to try and make that process much easier for you by giving good advice that will help smooth over these processes. So let's get into deceased estates. Explain to us, Tutu, some of the biggest problems that people encounter first of all when they are trying to wrap up a deceased estate or when somebody dies. What are the most common problems that you encounter?
Common problems, basically, they don't know where to start. I think that's, you're talking when you say having complications with the wrapping, that will give an indication that they've already started and they've reached a stumbling block. The problem is when someone dies, a lot of people don't really know what to do. They think they can just go to the bank. Okay, Aidan is passed. Okay, we're going to go to the bank and we're going to take all this money and then, distribute it among the family. It's not the case, So once a person dies, their estate is governed by the master of the High Court, right? So the beneficiaries at that stage have no right to this estate at the time. You can't, because what they want to do is also ensure that creditors are paid. So if you pass on and you're still owing your car or you're still owing a bond, those creditors need to be paid out.
So let's say a loved one has just passed away. Yeah. What would be, and you're now, let's say, the head of the family, and you're assigned now to deal with the deceased estate. What would your first move be? Okay,
so before the being assigned, I think, let's say, so if someone passes on, the first question that needs to be asked is whether or not this person had a will. Right? It might be difficult, people think, but how are we going to find that out? People, it's a will, so it's supposed to be secret. You'll find that the person, a lot of banks have systems where they allow their clients to have their own will so they can actually do a will with the bank. So the first place to ask would be the bank, right? So did this person have a will or not? And then goes, okay, sharp, no, you've got a will, here's the will. So that's the first thing you need to find out, because the will tells you how the assets are going to be distributed.
But in an ideal world, you would make a living will and you would tell your loved ones where to find this will before you passed away. So as a safety measure, in order to look after your loved ones and to make sure that they don't have too many problems, the first suggestion obviously would be to, rather than just make one at a random bank and then just go out and search for it, make one, tell them where to find it. Would that be a good suggestion?
Yeah. Make one. For instance, with the law firms, you sign 2 copies. So the law firm will have a copy, and you will have a copy at home.
And so what's better, a bank or a law firm to make a will?
Either or.
Okay.
I think it's at the preference. Maybe the bank might be cheaper because after you sign the will, you just pay storage for them to keep your will.
I understand.
Yeah, so very important to do that will, especially once you start earning an income. You start buying things. Have that will in place, even if you don't have children at the time. You've got parents, but maybe you want to give your house to your sister. So make sure that you do draw up this document that deals with things like that, and obviously change it or change it after every year because your financial situation does change. You might have lost a house now, or maybe you have bought in a new house, a new car, shares in companies. So always look into it every year, whatever period in the year. Just look at your situation. So okay, I've advanced this much. I think it's time for me to relook. Oh, now you're married now. So you're married, You've got a wife now, you've got children. So it's okay, fine. My situation has changed. I've got a family now of my own. Let me look into sorting out my affairs. Should I pass on? Make sure that the assets go to the right hands.
So ideally, you make the will, you make it organized. You can use your bank, you can use a lawyer, and what you do is you notify your loved ones. And in the end, you're not doing this for yourself. You're actually doing it for the people that you leave behind. You're doing it so that your children or your wife or your loved ones don't have financial issues in the immediate aftermath, and that the grieving process can be a little bit smoother.
Yeah.
Now, let's say hypothetically someone has died in the family, and you are now the head of the family. Let's pick up from then. What would that person now do?
Okay, so if there's a will in place, the will mention who the executor is, right? So the executor, maybe they've nominated that head of the family to do the distribution, to do the administration of the estate.
And when you're making a will, who's the kind of person that you would nominate as an executor should you pass away?
I would suggest that you nominate someone who's a little bit knowledgeable in things, but ideally that person will eventually have to approach a law firm or someone who specializes in estate administration. Because even if someone like Aidan, who's not a lawyer, might have some knowledge here and there, you report this estate to the master's office. They will say, okay, this estate has over a certain amount of money. We have a threshold of 250,000. So once an estate is valued at over 250,000, it means that there's a certain amount of legal processes that take place, drafting of a liquidation and distribution accounts and all these things that need to take place. And the master's office will feel comfortable if you went and assigned a lawyer to assist you with that. So that will be called an agent. Right? Okay,
so so you would now have made the will. It's very unfortunate someone's passed away, and whoever made the will has now assigned an executor, and that executor would obviously go to a reputable law firm, something like Mgiba Law, and you would then help administrate the will and help roll it out to its end.
Administer the estate.
Administer the estate.
So that'll be the process. You can nominate the lawyer straight away as an executor, but you'll find a lot of times like a mother would nominate the son. Or actually a lot of the times they might nominate the actual bank that's actually doing the will. And then the bank will have attorneys on their panel that they will assign the matter to, and then they will do the administration on their behalf. So the head of a family will just have to at least get to that point. Say, okay, fine, I've been nominated. I don't know what to do with this nomination, so let me go consult an attorney. So the attorney will go and say, okay, fine, he will ask you the basic things. There's a will in place. Okay, sharp. Where's the assets now? Are they still, available? Because remember, sometimes people do a will 5 years ago and they didn't update it.
Yes.
So you'll find some of the assets have been sold, and there's probably new assets now.
Yes.
So we do a brief consultation. Then we report the estates to the master's office. So that's done. There's
It's
by
the
filling
Master's
in-
Deeds Office.
No, the master's
Office,
office. The master of the High Court.
Okay.
Deeds office deals with property.
Okay, something separate.
Yeah.
Thank you for
they,
letting me know.
yeah.
Thank you.
So the master of the High Court, they deal with the guardian funds. They deal with trusts, insolvent estates.
Yeah.
Like if you become sequestrated or anything, liquidation of companies, that's all handled through the master's office. And then especially the deceased estates. That's where if you go past the master's office and you see queues of people, most of them, 99% of them are going for a deceased estate.
So now the executor is now in theory working a little bit with the legal practice who's taken it over, or the bank if that's the case, and they begin to then work on estates. Obviously the first port of call is they're going to pay off the debtors, is that correct?
Yeah, so basically what the law, so you report the estates to the master's office. There's actually documents that you need to sign and prepare. You can get them on the Department of Justice website. You get the documents from there, you download them, you print them, you fill them in, and then you report this. So once they report the estate to the master's office, they issue you with a letter of executive. So if your estate is over 250,000, I was explaining earlier, they issue with the document called the letter of executorship. Or if it's below that, they issue with a document called a letter of authority. So if it's below 250,000, letter of authority. The difference is just the manner in which the administration gets processed of it. If it's 250,000, then it's deemed a small estate. You don't really have to go through the rigorous processes that involve a big estate.
I understand. So it's much simpler for
It's
smaller.
much simpler. So you just take that document allows you to now administer the estate or continue with the next process. So if I have an estate of 250,000, less than 250,000, you find a guy only has like 50,000, I get a letter of authority, I take it to the bank, and then the bank will say, okay, I can pay out the money.
I understand.
So now with the letter of executorship, that's a big estate. The next process after that is to advertise. So this is where your creditors come in, because obviously your creditors at this stage don't know that you're late, right?
Yes.
So you have to issue a notice. It's in the government gazette, and in the newspaper that circles. So it's like Citizen
And big banks and lenders will monitor this government gazette on a regular basis.
Someone will be assigned to go to, because that's where you are. And also you would have notified the banks already also that this person is there, especially if there's a bond.
Of course.
So you would have notified them already. So they would have already, without even seeing your notice in the paper, they would have already corresponded with you, given you a certificate of balance to show you how much money still needs to be paid off, etc., etc. So you have to do this notice in the government gazette, in a newspaper. You have to let it circulate for about 30 days, I think. 30 days. And then once you've done with that, then you continue with the process. After that, you do a liquidation and distribution account. It's just a document that shows what your assets are in detail. So because at this stage, the attorney would have done a deep dive would have found out what policies you have, what bank accounts you have, what properties. We use a program called Windy that shows all the properties that you own, and that might not have been known to your beneficiaries and to your family, or might not even be in the will because you bought these assets after you drafted the will and you forgot to put it into the will. So
that makes complete sense.
Would have done a deep dive on all the things and you put it now in this liquidation and distribution account, which will show the assets, which will show the liabilities, and which will also show how those assets are going to be distributed.
Some of these things, though, I mean, you've given quite a lot of information, but in the end, a lot of these processes are actually not going to be handled by the mourners, So basically, in terms of the people that are expecting to receive assets from this estate, either goods or assets or cash, for them, the steps are basically, remember, make the will, look after your loved ones, go out, find a good law firm, get in contact with your bank, be responsible, make that will. That makes everybody's lives going forward a lot easier. You don't want to have your loved ones find that they're in a bunch of trouble. So we know that. You've now made the will. Hopefully this loved one's passed away. You know who the executor of the estate is, who's been assigned. They've gone to the law firm and the bank, and all these processes have started to take place. The publishing in the Gazette started to take place, but the lawyer or the bank will take care of that. The rest, I suppose, the executor will be assigned to the little bits and pieces of paperwork that are required. And now all of this has been submitted. So it's now gone to either the bank or the lawyers. It's been published in the Gazette. And now you've got the recipients of the estate, the loved ones, whoever it is. Let's say they're kids and they need that money. They need to pay university fees, or the wife has to pay for electricity or whatever it is. What can they expect from that point on, from the time that everything's been published in the Gazette and that the banks and the lawyers have been notified? What's their...
So administration processes on a good estate, with the will and everything, it's legally speaking, it's supposed to take 6 months. But unfortunately, there are hurdles along the way. A lot of the times it's unfortunately with the master's office. Severe backlog at all the master's offices, right? So you might submit a document today for approval, and it might take 2 or 3 weeks for you to get your thing back from them, consent from them. So those are the things that we have to keep in mind. Another thing that I also forgot to mention is that we opened an estate bank, and this goes directly to your question. We opened an estate bank account, right? So that's where all the accounts that the deceased had, we go to the bank and say, listen, we've got a letter of execution. Can you please transfer the funds from his personal account into the estate late account?
Yeah.
So we close off all the accounts, we transfer all the money into this account. Pension,
Yes, of course.
or investments that didn't really have nominated beneficiaries. So all that money then has to become part of the estate.
So the executor and the estate will now consolidate all the cash flows, liquidated assets into one account so that they can settle all the debts and then pay out.
Perfect. So, but because we haven't reached the stage where the master has given us distribution, consent to distribute, like you said, there might be situations where the children need money for school and whatever, all those things, school fees, school uniform, bond, or whatever. Not necessarily the bond, because the arrangement or whatever we made with the bank, but school fees, those imminent, urgent costs. So what happens is the executor can make a request to the master's office to release certain funds. Give them a brief story. You have to show that the actual assets in the estate exceeds the liabilities.
Of course.
So because remember, we do want to make sure
you're going to pay all the debts.
Yeah. So once that's done, then they give you the permission to do so. Then that's how you'll be able to handle the day-to-day costs during the estate process.
Now, I imagine it's a very sore point for families when they're in their minds, they expect a certain timeline and it stretches out. So they say in theory 6 months, just so that people can prepare themselves. What in your experience is the realistic timeline, not the 6 months advertised by the legislative system?
Like if it's a good estate. When I say a good estate, there's a will in place, there's no funny situations, no stepchildren coming out from, illegitimate children coming out from the woodworks, or a wife on the side that no one knew about. Like if it's a proper estate, everything's in line, everything makes sense. I'll give it about a year.
Okay.
Or a little bit over.
Could even be longer.
And that's only because of, from the lawyer's side, they'll make sure everything's done, straight away or within a reasonable amount of time. It's just that now you remember you're dealing with third parties, you're dealing with another party that has to do the adverts.
Of course.
You're dealing, and they could take a month to actually put out the adverts, depending on the communication that you have with them. You're dealing with the master's office, who could take a month or two to to revert, on certain situations. So it's not necessarily from the attorney's points. It's more the third party that we have to deal with to ensure that this process gets done.
Now that you've explained it to me, I way over imagined how complex this whole thing had to be for the family. Because the truth is that it needs to be complex for you or the bank, the lawyer or the bank. It has to be a tiny bit complex for the person who is assigned as the estate executor. But in reality, if the family and the person who's passed away have done everything right, they've gone out, they've made their will, they've notified their family as to where they can find it, it's been updated, everything's in place, then it's quite simple. They'll pass away, you'll know where to find the will, you'll take it to the lawyer will go to the bank, they'll advertise in the gazettes, they'll get all the processes going, they'll pay off the debtors. If you have an issue, you'll go to your lawyer or to your bank to say, we need food for kids, or we need to pay for school uniforms, or whatever it is. That exists as a possibility. It honestly isn't that complicated. I think the two big things are this. Make the will, make sure it's updated, make sure it's good. The second thing is find somebody that you know is going to be competent. Like if I had to deal with an estate tomorrow, I know it comes straight to you. Because the complicated stuff that you're talking about, honestly, it's too complicated for me. I wouldn't want to deal with it. And that would be how it would be for you at home. You wouldn't have to deal with the messy part, but you would need those two places, things to be in place. Now, as a last note, because we're kind of running out of time, that is the less complicated one. Now let's talk about a messy one.
Yes,
just a few points where someone has not been organized and there's no will. Nobody knows where to find a will. Give us maybe 3, 4, 5 quick pointers on the complexities of that and where those people might want to start.
I think before I even address that, and this is a point that I always have to put out there if I'm given this kind of platform to talk, I think it's very important, especially amongst people in our Black communities, that we have these conversations with our parents, right? We sit down with them, or whoever's looking after us, right? Our guardians could be our grandmothers, We have these conversations like, have you drawn out a will? I don't want to necessarily know what's in the will, but can you please draw out a will? And also, not just that, also know the financial, now we're older, my parents thankfully are still alive. I must be able to have these conversations about their finances, right? Because a lot of the times we think our parents are doing fine, then they pause only to find that there's a crazy amount of debt in the estate. So we need to, those conversations need to be had amongst us Black people and especially people in our generations and their parents, the living parents.
Wow, that's excellent advice.
That needs to be done, so that when they pass, everything is fluid after.
And this isn't just legal advice. This is lived experience. Because you can technically Google the textbook, but you can't Google this.
It's life, It's a different situation, So that aside, that needs to happen. The complex estates come from that lack of communication. When you find a situation where the family is left with the parents have passed on, and there's a house that's owing the bank of maybe 200,000, and the people, the beneficiaries, don't have that money. So the only resort is, but they stay in the house. So the only way they can pay that debt is to sell the house. You see, now they're left homeless, or they maybe get whatever money from the sale, and they have to buy a 2-bedroom somewhere, and it's like 6 people. So those are the issues that we encounter a lot. We call it an insolvent estate. An estate, also, when there's no will, we call it an intestate estate. So in that, those are the cases that also are very problematic, because
people might want to fight.
People, they will fight. And the certain people who are not, in terms of the law, there are certain people who are immediate beneficiaries. So if you and your wife pass on, your children are the immediate beneficiaries, right? So you'll have cases where we had a case where a guy, his father killed his mother and he killed himself, right? And he left children behind. And then what we found was the brothers of the father then went and just basically took over the house and kicked the kids out of the house and said, no, we're entitled to this house. That's my brother. But legally speaking, they're not entitled to the house. The nearest beneficiaries are the children, the descendants. That's an intestate succession.
I think that maybe what's happening here is what you're talking about is maybe a small amount of contestation over cultural law with practices of inheritance law that might clash. And I find this amazing because your advice, I mean, I'm obviously not a black guy. I think we can all see that. But I personally think your advice is amazing. I'm going to take that advice. Like, I'm going to go now to my mom and say, you know, do we have this kind of thing in place? Because you're 100% right.
It's not just also, I think it's also the people who just feel entitled to your stuff. You know, I'm like, no, man, I grew up with Aidan. I must, you know, people who envied you or whatever. So now that you've gone, they're like, no, I'm gonna take over.
It's amazing. You can almost disrupt your legacy by just not making a proper will. It's crazy. It's crazy.
Yeah. So yeah, if you know, especially guys who have a lot of, guys who are married and then they have children outside that the family doesn't know about. Very important. You need to do a will. Yes, your family will find out about these other children because remember, illegitimate children are still deemed children of the deceased. They whatever the main children in the marriage are getting, they are more entitled to just as much as they are, right? So there's no differentiation. So if that is the case, if you have children outside and you haven't told your family, at least put it in the will. So that,
of course.
I mean, yeah, it'll be kind of crappy that they find out after the death, but at least it's in writing and there's no disputes. Right.
That's unbelievable.
They can fight all they want, but it's in writing. The guy signed that he wants his car to go to Usbusiso and then the house must go to Mbali or whatever, you know. It's in writing. And that was his, you know, it's according to his wishes.
That advice is as good as it gets. Before we wrap up, if I can ask you just to do 3 points, boom, boom, boom. If it was you, let's say your spouse has just passed away, hypothetically, let's say you've got kids in a relationship and there's no will. What would be the first 3 things that you would do to try and resolve the problem? Would you still, because there's no will, would you still go to a lawyer? Would you still go to the bank?
Definitely. First things, you go to the bank.
First thing.
Let them know. Cool. Try to get a statement because a statement will show all the payments that the deceased was making every month. Because if there's a policy, funeral policy that you didn't know of, you know, pension policy, they could pay out very quickly.
That's amazing.
Right? All they need is a death certificate or whatever. So at least that could cover funeral
costs and stuff like that.
Longhand, yes, you need to go to a lawyer. And the good thing about estate administration, there's little to no fees up front. The attorney gets their fee at the end of the administration. Yeah. So you won't be going to an attorney and paying them 50,000 on the jump. Then there's a bit of a problem there, you know.
That's amazing.
So a lot of the times, maybe you say, okay, no, we'll take a fee to open a file, maybe 5,000 or 2,000, whatever. But then they do the administration process from there.
What fantastic information. You know, so remember, if you're having problems like this, you can approach a reputable law firm like Mgiba Law, and you won't have to pay them up front. They will take over the process from you, and the fees are regulated. You can ask them about fees up front, and they'll take it off at the end of the estate, and you can remove some of the headache from the grieving process. So that's amazing.
The fee at the end of the day is 3.5%. So, but you have to make sure, please, that you approach a firm that does estate administration. Don't just go to, there'll be a criminal firm that does criminal law. They won't know how to handle an estate administration process. So just make sure that you go to a firm that specializes or at least has that on their profile.
Definitely.
Yeah. So you don't want to go to a firm that then has to assign the matter to another firm.
Law firms are like doctors. You know, you don't go to an ear, nose, and throat doctor because your foot's sore. You know, so that's really good advice as well. So then, just the last 2 points. So now you've done that. You've gone to the lawyer and the bank. You've notified them. What would be the next 2 things that you would do? Just as we're wrapping up, in the instance where there's no will, or do you just take it to the lawyer and hand it to them?
Yeah, once the lawyer's with it, then the lawyer's run with it. There's not much you can do from there because obviously there's a lot of legalities involved that you wouldn't understand. But just communicate with the rest of the family and say, look, the matter's being handed up to the lawyers are dealing with it, and whatever communication I get from them, I will communicate with you guys. And tell them to be patient, because it is a very drawn out process, unfortunately.
What valuable information, because we've taken something that's very common in South Africa. There's a lot of anxiety around it. It's something that's often difficult for families to deal with. It tears people apart, creates a lot of frustration. And here we've got someone who's come in and they basically cut it down into a simple few steps. Go out, make a will, make sure it's up to date, make sure your family knows where to find it, or your loved ones in the event that you pass away. When you do, they'll have the will, they'll take that will to a legal representative or the bank, the representing bank of the deceased, and they will simply take over these processes and they will facilitate things like if you require money in the meanwhile for necessities like school fees or food or something like that, the lawyers will help you out. And it's actually really simple. There's not too much to it. I think it's something that I overplayed in my mind. I overcomplicated it. The complex stuff are for people like you to deal with. We just got to know where to pass the ball at the right time. And then the other scenario, which we spoke about, where you haven't made a will, someone's been naughty, they've been a little bit irresponsible. There's only one step in the process. Go out, find a good, reputable law firm who deals with deceased estates, not with injured foots or ambulance chasing or some funny stuff like that, and hand the process over to them and work closely with your lawyer to try and resolve the matter as soon as possible.
Definitely.
If you would, just as we close, where can they contact you? Do you have a website, an email? What would you like to hand out in case?
The website is still growing, but you'll find me on the socials. You can type in Tutu Mgiba. You'll find my Instagram account, my LinkedIn account, Tutu Mgiba. Mgiba Law on Instagram. You can check me out there too.
I know that he's done fantastic work for us, and we look forward to working with him more in the future. Thank you very much for joining us. That's Deceased Estates. Bye for now.